people can hear us.
Yep.
Okay, I'm going to broadcast, let people come in. Okay, awesome. We got people coming in right now. Yep, guys, if I call your name, just type yes, right? AC, Arjan, David, Gan, Jason, Kaylee, Kai, Lei Ping, Lina, Martin, King Min, sorry. A lot of people, so I cannot call out everybody. So just a quick questions, whether you are in Facebook right now or on the Zoom, just type in the chat box, let us know. I want to ask you questions. So are you currently like staying in a high-rise building, or you own any property that is a high-rise building, right? So normally it's under a Strata title. And if you are, type yes in the chat box or in the comment. Type yes. If no, you can also still participate by typing no. Just type no. I guess most people will be yes, right? This will be something concerning you guys here. So we're going to start right on time. Another 2 minutes to go.
Okay.
Okay, guys, please, if you are staying in a high-rise building, or if you own any property that's a unit in a high-rise building, can you type yes in the chat box? If no, you can just type no. And then for Zoom, you can see that we have two places you can type. So one is the chat box. Chat box is meant for chatting. And then the Q&A box is meant for asking questions. So if you have questions, you make sure you put it in the Q&A box so that it is easier for us to monitor, and hopefully we won't miss your question. Okay, so yep, 1 more minute to go and we're going to start right on time. Thanks for tuning in early. But sometimes people who are late, they will not be able to get on Zoom. And today, I think Zoom, we are going to max out the maximum line of 100 as well. And for those who cannot make it online on Zoom, you can always go to my Facebook page and it will be there. It will be on the, I will pin it on the top. So let me pin it right now. So whenever in the future, if you cannot log in the Zoom because of the full capacity, then you can go to my Facebook page, which is facebook.com/KCLawmoney, to look for the live stream happening concurrently. So, okay, I'm going to pin this. Okay, good. So time is up. Thanks everybody for tuning in. This session is about everything you need to know about Strata Management Tribunal. And we're going to talk about the function of the Strata Management Tribunal, and you're going to know the common problems filed to the tribunal. I guess you might have faced this kind of problem before, and who can file a claim through the tribunal, right? We will get to know that. And then the procedures of filing claims and the counterclaims, and how to execute the tribunal award, and can you challenge that? Can you challenge that tribunal award? So before we start, I want to announce that I just bought a couple of books from Ng Wei Yik, the author of this book called Strata Management Tribunal. And I'm going to give away a few copies. So I decided to give away 5 copies. So this is out of my pocket. I'm going to give 5 copies to 5 lucky attendees of today's session. So how do you qualify to get into the lucky draw? Is you have to do 2 things. So the first is you have to go to my Facebook page and then share this video, live video, just share. And when you share it, you hashtag Strata Management. So just hashtag Strata Management and share this video to your friend. So for those people who share and hashtag Strata Management, then you'll be in the draw lot so that I can pick 5 lucky winner. After this session, I'm going to choose that 5 persons and I'm going to message you privately to get your mailing address so that I can ship that book to you. I already bought the book. It's in my office in Malaysia already. So today, without further ado, I'm going to introduce the speaker. He's Mr. Ng Wei Yik. He's former Penang State Assemblyman for Komta until 2013. He's also former Tanjung MP, 2013 to 2018. He has served as the special coordinator to the then finance minister until February 2020. So Mr. Ng Wei Ek is currently a registered property manager and a commissioner for OPS. So he's the book author of this book called Strata Management Tribunal. So this is the book where I'm going to give away. So 5 copies for you guys. So please just go to my Facebook page, share this, and then hashtag Strata Management. So just do that. And without further ado, Mr. Ng, I'm going to leave it to you to educate my audience about this.
Okay. All right. Yeah. First of all, I would like to welcome everyone on board. A happy morning to everyone. I would like to thank Casey Lau for approaching me to go on the live webinar on this very rare topic, Strata Management Tribunal. In fact, it's a very important topic for all the property owners for the high-rise building. If you are owning a property in the high-rise building, I think even in the commercial shop lot, even in the gated community, you need to know more about the Strata Management Tribunal. It's a good mechanism for you to air to fight for your own benefits, to seek the justice over a lot of issues concerning the management, corporation, or the JMB. Especially when you are having the issue of the interfloor leakage. I think it is a common problem for the property owner. Before the tribunal was set up, a lot of people finding no way how to get the justice over the interfloor leakage, because there is no mechanism. Before that, there was under the Strata Title Act 1985, where the law allowed the setting up of the Strata Title Board. But in fact, the Strata Title Board was not functioning in a lot of states. Maybe only in Penang they get the Strata Title Board, but in a lot of places they cannot even get the Strata Title Board be set up. So a lot of such an issue, they find nowhere to file the complaint. In the end, the affected owner has to fork out their own money to get the thing repaired. So it's very injustice to those who are the affected owner. In fact, those responsible owners should fork out the money, and not the affected owners should fork out the money to repair for themselves. Yeah. So I hope that I can share with you a lot of things, how to get the thing done through the Strata Management Tribunal. In fact, it's a very cost-saving option. Instead of engaging a lawyer, you don't need to go through a lawyer, but you have to act as a lawyer. You have to act as a lawyer, because lawyer is not allowed to be represented a client to representing a client in the tribunal. You have to act for yourself. Maybe I will go through some slides for that, but the PowerPoint to ensure that you get a clearer pictures over my presentation. So this is my book, so you can get it in MPH or other bookshop, or if you want to get a book, then you can also approach me later. Okay, just now Casey Lau already explained to you what are the main topics I want to touch on today's webinar. Okay, let me give you some background.
Mr. Ng, do you want to put on your slideshow mode?
Yeah.
I mean, put it on full screen.
Yeah. Oh, it's not on yet. Sorry.
Hey, no problem. We don't want to give a spoiler because they can see your next slide, right? Okay.
Okay.
Yep, it's now full screen. Yes.
Full screen. Okay.
Yep.
So it's on the screen. All right. So in fact, we have 2 types of tribunal set up. One is way back to 2003. There was already a setup for a tribunal set up for home buyers claim. If you have any issue relating to the SMP, the sales and purchase agreement with the debtors, and also some problem with the defect liability period, or over the late delivery of the properties, you can make a claim against the debtor. And the limit of the claim is only 50,000. That's not more. Okay. And then for tribunal, management tribunal, Strata Management Tribunal is operating since 1st July 2015. After the new act of Strata Management Act 2013 come into force. So it was then it's governed by the Strata Management Tribunal Regulation 2015. Then this one is solely on the management, strata management. So any dispute between the owner and purchaser with the debtor, if the debtor is in charge of the management, or GMB, MC, subsidiary MC, or managing agent appointed by the COB, if you have any problem dispute with them, you can file against them through the Strata Management Tribunal. And the limit of the claim is 250,000. Okay, so there's two avenues for you to go. You have to check whether your problem is relating to the SPA with the debtor, or your problem is relating to the strata management or the common property, or any issue with the management body. Then you go to Strata Management Tribunal. Next one. Okay. So where is the tribunal set up? In fact, it's under Ministry of Housing and Local Government. This is the headquarters. Our headquarters in the KPKT in Putrajaya. Okay, you can go there. You can file your claim. This is for Klang Valley. For those staying in Klang Valley, those staying on the northern part, those staying after Ipoh. Okay, after Ipoh, if Ipoh, you have to go to Penang to file your case. Then anyone stay below Ipoh and then up to the NS, then you have to file in Putrajaya. Then there are some regional office. There are northern office in Kebrabatas. For those staying from Perlis to Ipoh, you have to file to Kebrabatas. For those staying in Malacca and Johor, then you have to file to Southern Zone in Johor Bahru. Then for those staying in Kelantan, Terengganu, Pahang, then you have to file your case in Kuala Terengganu. So it depends on where you located. Okay. Then tribunal comprising of a chairman, a deputy chairman, and not less than 20 members. We call them presidents. They are appointed by the Minister of Housing and Local Government, who is now the OIB Juraida. So they are appointed from Judicial and Legal Services, and among the lawyers with not less than 7 years standing. Okay, so they are quite experienced lawyers who are able to deal with the strata management issues. Okay, the tribunal setup is some sort of like a courtroom, okay, but it's a layman's court. So anyone you can go, but you can go and then present your case, make your argument there. So tribunal, in that sense, only comprising of 3 parties: the president, who will be presiding over the sitting, and then a claimant and a respondent. With these 3 parties, the tribunal can have their own sitting anytime as arranged by them. But you must act like a lawyer lah. No lawyer can be representing you in the tribunal. Okay. What are the common problems filed to the tribunal? The most common one is the interfloor leakage. The second common one is the default of maintenance charges. This usually is a claim by the GMB or MC against the owner, against the defaulters. And then if the owner has any unhappiness over the calculation of the maintenance charges or late payment interest, they can also file against the GMB, MC, or the debtor in the tribunal. Any encroachment onto the common properties, okay, maybe you try to put a lot of things, obstructing others on the corridor, on the staircase, all these things can be filed to the tribunal as well. Any breach of bylaw, maybe you put up illegal extension, illegal structures, all these things you can also refer to the tribunal as well. But then the bylaw I mentioned here is about what is stating in under the schedule of the Strata Management Regulation 2015. That means you must follow the bylaw. Now the government already set a standard bylaw for all the high-rise property, all the high-rise building under the GMB MC. So they must follow the bylaw. No more your own house rules. No more you don't need to follow your own deed of mutual covenant, your own DMC. You can throw everything into the rubbish bin. You must follow the standard bylaw set by the government. Where to find the bylaw? You can buy the Strata Management Act 2013. Then under the behind the book, at the later part of the book, you can find the whole set of bylaw. Follow that.
Wow. So this is like one set of rule for everybody.
Everybody,
Wow.
standard.
Okay. Oh.
You can make addition to it, but whatever provided there, you cannot change. You cannot amend also. So it provide the basic protection to all the property owners. So a lot of people, a lot of strata building, maybe they still follow their own house rules. In fact, that's not the right way. You can abandon it. You don't need to follow that. You follow the bylaw provided by the government, or because it's gazetted. All right.
Okay.
Then on the failure to call the first AGM of the JMB MC by the debtor, the first AGM must be called by the debtor, but if the debtor do not call for it, then you can also file to the tribunal. Definitely, before anything goes to the tribunal, you can try to make the complaint to the COB first. But if the COP do not take any actions, then you only file to the tribunal. Don't directly go to the tribunal before you try out the option given by the COB.
Sorry, can you explain COB?
COB is the commissioner of building. Okay, the person empowered under the law to oversee all the issue with the relating to the JMB and MC or all the stratified buildings.
So each building will have one COB?
No. Every local council will have one COB.
Oh, okay,
usually the mayor or the president of the council or the chairman of the local council, they will be appointed as a COB. Okay.
Okay.
So it depends on the location where your property is, then you refer to the COB. Go to the local council, find the COB. Usually is the mayor himself. And then any non-compliance by the management committee. Let's say failure to call the AGM or EGM in time. Every 15 months, you have to call the AGM, okay? But failing to call, or any committee overstay, they are on their tenure, because chairman, secretary, treasurer, they cannot be the chairman, secretary, treasurer more than two years, okay? If they overstay on their tenure, and then any committee, they have already over 3 terms, but they still continue to stay on, then that is an issue, is against the law. You can file to the tribunal to disqualify them. And then unhappiness over the COB decision or directions, then you can also take the COB to the tribunal. Okay, maybe the COB nullify your AGM or EGM or anything, you refer to the COB, but they do not take any action, then you can also file to the tribunal. So that's a very very convenient for all. You can take anyone to the tribunal, but so this is a list who can file their claim to the tribunal. Definitely debtor, a purchaser, or a proprietor. What is the difference between the purchaser and proprietor? Proprietor means your name is registered on the strata title, then you are proprietor. But before your strata title is out, your name is appeared there, you are only considered a purchaser. Then a joint management body, MC, then you can also file your case. A subsidiary MC is usually subsidiary MC is a form for the mixed development project. So under one building, you can have one main MC, then you can have more than one sub MC to manage different segment of your property. Okay, so here there's one category for a managing agent. You must be carefully study on that. The managing agent mentioned here is not the property manager. You cannot simply take your own property manager to the tribunal. In fact, it's not allowed. This managing agent is those appointed by the COB to take care of, to manage certain property, that they are called managing agent. Only those appointed by the COB, if they have anything, you are not happy with them, then you can take them to the tribunal. And any other interested person with the leave of the tribunal, then you can try. If they are not fall under this category, any other interested person, but you need to seek the leave from tribunal first. Okay, the advantage and disadvantage of tribunal. Okay, the most advantage thing, the Limitation Act 1953 does not apply. That's very important. if you are owing your service charge more than 6 years, the management body can still claim against you. Okay, even up to 20 years, there is no time limit. Okay, this is very important. You don't think that you don't claim that, oh, my outstanding is more than 6 years, you cannot claim whatever owed to you 6 years ago, more than 6 years ago. That is now allowed under the tribunal. Okay, so that is helpful. Definitely, you can also produce your own witnesses, or you can summon anyone to be the witnesses to testify in the tribunal, but you must examine your own witness. You can do the cross-examination, you can re-examine the witnesses of the opponent parties, so that's allowed, but you have to do your own. The lawyer cannot help you at all. Okay, one more important thing. Any case filed to the tribunal cannot be filed to the court at the same time. Okay, or any case filed to the court cannot be considered by the tribunal. So you have only to choose one. Okay, sometimes if the same case filed by a different party on the same day, then which one comes first? It depends on the time of the filing. So if anyone filed to the court earlier than the tribunal, then that one, then those filing earlier cannot be considered by the tribunal. Okay, so but they are also one in disadvantage of the tribunal, because different session will be presided by different president. So there may be some inconsistency in terms of the decision made by the tribunal president. But you cannot have access to whatever decision made by the any other president so far. So you cannot have access. You cannot go to the website, KPKT website, to have access to all the decision made by the others. So there may be some inconsistency between different presidents. Okay, what other cases cannot be filed or is not under the jurisdiction of the tribunal? Land or strata title issue is considered land issue. Strata title also land issue. You cannot file to the tribunal. Issues of a guarded neighborhood, residents associations, those who are under resident association, no GMB, no MC, that means you are not stratified project, then you cannot file to the tribunal. Like what's shown in the pictures, a lot in Klang Valley, I think a lot of community, they simply engage their own security guards, they put up their barricades. This is not the gated community. This is only considered as guarded neighborhood. They cannot form their GMB MC because all their roads already surrendered to the public authority. So they have no control over the road. Okay. Any dispute between the GMB or MC with the property manager, if anything relating between these two parties over the contractual obligation by the property managers, you can only go to the court. Okay. But if anything done wrongly by the property managers, can you file? Can an owner file against the property manager? No. Whatever thing done by the property manager is you can only file against the GMB or MC. Okay, because they work, any property manager, they are working for the GMB or MC. So you cannot file directly against the property manager, but you can file against the GMB or MC for whatever thing done by the property managers. Okay, any dispute between the purchaser and the debtor over the sales and purchase agreement, including the deferred liability periods, including late LAD, liquefy and certain damages. That means any property surrendered to you late, then you can claim the interest against the debtor. Any tenancy issues, including the illegal homestay, Airbnb, you cannot file in the tribunal as well. You have to go to the court. Anything inside the individual premises, which is not part of the common property, including renovation, illegal structures being put up, all this you must go to the court, or you refer to the local authorities, refer to the other department, not COB department. A lot of people tend to make their complaint. They thought anything happened inside a high-rise building, they only refer to the COB department. In fact, it's wrong. You must refer to the other relevant department, which may be comprising of the licensing department, building control department, you see what type of your problem relating to. Okay, and any matters not fall under the powers of COB, you cannot file to the Strata Management Tribunal, including the illegal hawkers, the eddies, the mosquito breeding, parcel rent, assessment rate. Parcel rent is now the quit rent for the high-rise building. They call it cukai petak parcel rent. Okay, all these are under parcel rent is under land office. Assessment rate is under local government. So all these issues you cannot file to the tribunal. Okay, so on the procedures, I don't want to talk in lengthy, but just for your knowledge, how to file a claim or make a counterclaim in the tribunal. Okay, the first thing, you must issue notice of demand. Okay, if for defaulters, the notice of demand will be in the form of Form 11, Form 20. Form 11 is for the GMBA, Form 20 is for the MC. You must use the form prescribed under the law. Okay, you must issue the Form 11 or 20 to the defaulters before you can file to the tribunal. Okay, but in some areas in Putrajaya, maybe even before Form 11 or 20, they need you to issue another notice of demand. So you must check carefully because in Penang, in earlier stage, they asked for another NOD to be issued, but at the late, but now they do not require us to issue another NOD. Okay. Then for interfloor leakage, where is the authority for your claim? The Form 28 is a must. So if you have any problem on the interfloor leakage, you must ask the management body to issue you Form 28, sorry, Form 28. Because without Form 28, you cannot file to the tribunal. So you must insist the management body, whether they like it or not, whether they want to repair or not, they must issue you Form 28 after the inspection done. Okay. So with this NOD, Form 11, Form 20, or Form 28, then you can only file your case to the tribunal. The first document you use is Form 1. This is a statement of claim. After you file to the tribunal, you must serve to the respondent within 14 days from the filing date. Then when the respondent receive it, then from the day they receive, then they have to prepare. They have to prepare a statement of defense and counterclaim within 14 days from the receipt date, and also to serve to the claimant within 14 days from the filing date. Okay, so the maximum you have 28 days. Okay, then following Form 3, if the respondent make any counterclaim against you as a claimant, then you only need to file Form 3 as a defense to your counterclaim. If they do not make any counterclaim against the claimant, then you don't need to file Form 3. Okay, and then even though you are not happy with the defense to the counterclaim, and then you want to make any rebuttal to the counterclaim, you want to make any rebuttal towards the defense to the counterclaim, you cannot file any more statement for that. There is no Form 4 for that sense. Okay, some people are quite creative. They try to they use back Form 2 as Form 4. Try to put up another defense towards the defender of the counterclaim, but in fact it's not allowed. So you don't try to manipulate the thing. Okay, just follow that flow. Then whatever you want to say, you only say it in the tribunal during the hearing. Okay. So after everything is done, then you have to wait for the hearing notice. Usually, the hearing notice will be received within 1 to 2 months after the Form 1 is filed. Okay. Sometimes they won't wait for Form 3 to be filed. They already fixed the hearing. Then you will receive the hearing notice. Okay. And then award will be given on the date of hearing. If either the claimant or the respondent is absent during the hearing, it won't dampen the tribunal to give the award. The award can still be given even one party is absent. Okay, but if both parties are absent, then the case will be struck up. Okay, then you have to file again. Okay, these are tribunal fees. So these are the fees prescribed for different filing process. So if you are filing a Form 1 for residential, it's only 100. If for commercial, industrial, it will be 200. It will be 1/4, 1/4 more than the residentials. Then for Form 2, also same. Form 3 is cheaper. Definitely for you can see that Form 12. Form 12 is for you to pay to the person summoned. Anyone you want to summon to be the witness in the tribunal, you have to pay them 100 ringgit. Okay. So if you want to be the witness, you can earn the money there. Okay. Filing Form 14. Okay, if you have anything you want to apply to the tribunal, you can use Form 14. Then if you are, even though after the award is given, but if you think that the award should be set aside, then you can file Form 16. So the filing fee for each process will be around 50 to 200 ringgit. It's quite cheap for that. Okay, in comparing with the engagement of a lawyer lah. All right, service of document is important because everything must be served first before you can file to the tribunal. Okay, there are 3 ways of services of documents. The first one is by personally. Personally is by hand. You can serve to the opponent party. Okay, but this one must be done with the personal acknowledgement by the recipient. The second one is by the registered post. In fact, you don't need to go use AR registered post. You only need registered post. Okay, AR registered post, you need the recipient to sign on the yellow card. But registered post, you don't need someone to, you don't need the postman to return you the yellow card. Okay, in fact, the law says you only need registered post. Okay, then if you use registered post, even though the letter are returned to you, no recipient. Okay, the house is empty or the owner already moved out, no one in the house, no one can sign acknowledgement of the registered post. The letter already returned to you is considered served. Okay, considered served, deemed to be served. So you don't need to worry about that. If even without recipient, as long as you can show that the registered post is sent, then the notice is considered served. Okay. By attaching the document at a prominent part of the last known address. Okay, even though the house is empty, no, in fact you can put the notice on the grill door. It's considered served as well, but you must take the photo to prove. Okay. Personal claim cannot be represented by others. Okay, if you are an owner, you are facing the issue of interfloor leakage, and then you want to file against the owner living on top of your house, the upper floor, then you must make sure that you are able to appeal, to attend the tribunal hearing, because individuals who make a claim against the others, you cannot be represented by the others. This is very important. Even by your family members is not allowed. Okay, if you want to make a claim, on the date of the hearing, you must apply to the company for leave, okay, for annual leave, to make sure that you are able to attend the tribunal hearing. Failing which, your case will be struck up. Okay. If for the GMB MC, who is one party to the proceeding, then in fact it can be represented by any committee members or the property manager or any other authorized person who is not part of the management. Okay, but with the authorization letter being signed and given to the authorized person. Okay, if the debtor, they can be represented by the director of the company, property managers, any manager of the companies, or any authorized person who is not part of the company. Okay, for sure with the authorization letter again. Any owners who are bodies, corporates, if the property is owned by companies, registered society, or statutory body, they can be represented by the directors, committee members, or any other person. Okay. All right. So come here. How to make a successful claim against the deporter. Okay, this is a question concerning the management body. In fact, under the law, it is mandatory for the owners to pay their monthly maintenance charges or service charge in time. Okay, you must pay in advance, because when you sign the SPA, in the SPA, it's already clearly stated the service charge must be paid in advance. Okay, not at the end of the month. Okay, so you will be given, usually you will be given 14 days to pay your service charge. After 14 days, the management body, they can impose the late payment interest on your arrears. Okay, and you have no way to reject or deny any claim as long as the maintenance fees are calculated, imposed accordingly. How to impose accordingly? Because then you must follow the Strata Management Act 2013. There's a formula for that, how to be imposed, how much per share unit, everything must be calculated accordingly. And also in line with the decision made by any AGM or EGM. Okay, if your late payment interests are not calculated correctly, using the wrong way to calculate, then the tribunal can set aside part of your claim, not allow the late payment interest to be recoverable through the tribunal. So you must make sure you calculate accordingly. It must be on daily rest. Okay. Then the late payment interest cannot be more than 10% per annum. Okay. If you impose a late payment interest more than 10% per annum, even is allowed by the AGM or EGM, in fact, is against the law. It's a breach of the law. Then it can be set aside, not to be allowed your claim by the tribunal. And you cannot avoid to pay maintenance charges due to the service quality of the property manager, due to the interfloor leakage unattended by the JMB or MC. Okay, even though you are not happy, you are not really happy. The property manager is so, the service is quite worse, but that is not the reason you can be cited during the tribunal. It will not be entertained. Okay, as long as the money invoices or statement of account are served to the owners every month. Sometimes some management body, they only issue quarterly. As long as it's served, it's sent to your letterbox, then the fee are calculated correctly, then you have no any reason to avoid payment of the service charge. Okay, so usually for the management body, when they file a case against a deporter in the tribunal, usually the success rate is 100%, almost 100%. Okay, unless you calculated certain thing incorrectly. The awards of the tribunal can be given. Okay, even one of the party did not turn up in the tribunal, they can be given. The awards can be given in different form. Form 6 is award by the consent, both parties agree to it, agree to the claim, then award can be given. Then award for claimants, even respondent did not file a statement of defense. Okay, respondent did not file Form 2, only Form 1 is filed by the claimant. Then the award in Form 7 can be given. Award can be given in Form 8 where respondent admit the claim. Award for respondent where claimant is absent. If one party attended, then the award can be given. Okay, and you cannot say unless you prove that you do not receive the notice of hearing, then you can set aside the award. Then award for claimants where respondent is absent, then that is in Form 10. Then award after hearing, then Form 11 will be given. All these are different type of awards. It depends on whether you file the statement of claim, whether there's a trial, there's a hearing for that. So different form will be used. Okay, just now I say Form 16 can be given to set aside the award if you are able to prove that the notice of hearing was not received. Okay, that's important. Only by then you can set aside the award, then you can ask the tribunal to rehear the case. If the claimant was withdrawn by the claimant without liberty to file fresh or struck out by the tribunal due to whatever reason, then the same claim cannot be filed again through the Strata Management Tribunal. So you cannot simply withdraw a case unless with the liberty to file afresh. You can ask the tribunal to give you the permission, the liberty to file afresh. Okay, sometimes you file wrongly, you make the wrong claim, then you can ask with the liberty to file afresh, then you withdraw your case, then file again, but you need to spend again. Okay. So, okay, this is one of the precedent, one of the case I handled before. Is in the Gurney Park condominium in Penang. This one owner filed against the MC, filed against the property manager, filed against the COB. In fact, it shows that you can take COB to the court for whatever claim you want to make against them. And costs can be awarded. Okay, you can, same as what happened in the court, sometimes the lawyer will ask for the cost. But the cost given by the tribunal may be lesser, maybe only 100 to 500, not much for that. Okay, but you can ask for that, at least to offset the expenses borne by the management body in filing the case. Sometimes you can ask for miscellaneous charges or to ask for the traveling cost. All this can be allowed. It's part of the cost given by the tribunal. Okay, I have one interesting case I can show you. This was one of the case I handled before. It's between the MC of Gurney Park condominium against the Lighthouse Envelope St. John Berhad. Okay, this case is quite interesting. Why? Because the MC only claim against an owner, which is a company, okay, for the for service charge they owe to the MC. Okay, so they claim for around 20,000. Okay, but this owner, they file against, they make a counterclaim. Okay, in fact, you can make a counterclaim. Okay, he made a counterclaim up to 98,000 because he claimed that there was an interfloor leakage issue did not handled by the management, and then causing him loss of use and enjoyment of master bedroom from August 2010 until January 2017. 98 months. He claimed for 98 months on the average market rental of 1,000 ringgit per month. So he asked for 98,000. Okay, he also claimed for interest, 8% per annum, general damages, special damages, costs, or other relief deemed suitable by the tribunal. But all these claims were denied by the tribunal. Okay, if you owe to the MC, even though you have others issues not attended by the MC, that is not the reason you not to pay. Okay, and this case has been dragged for 513 days from the date of his filing, or even the examination and cross-examination of the witnesses. Okay, one whole day is used to cross-examine and cross-examine the witnesses. Yeah, so we also need to prepare the written submission, reply to the submission, as well as compile the bundle of document and bundle authorities, same as what a lawyer need to do for their clients. Okay, but finally we get our, after deducting 3,200 plus, okay, no, sorry, after deducting 3,400, the court allowed his claim, his counterclaim of 3,437, 3,437. Okay, because it based on one agreement entered between both parties a few years ago. At that point in time, both parties agreed that okay, 3,400 should be given to compensate him for the damages due to the interfloor leakage. So after deducting 3,400 from the amount we claimed, then we get back 14,851 ringgit within 30 days from the date of tribunal awards. Okay, but subsequently after that, he still filed the case to the High Court for judicial review. Or he claimed that his issue was not trial, was not here before the tribunal, but it was not successful. Okay, the judicial review was not successful. Okay, so that one I will explain later how to file the judicial review. Okay, Then after you getting the tribunal award, is an award. It's not the court order yet. How to make it as a court order? The tribunal award must be registered with the court for it to have effect of a court order. Without registering with the court, you cannot. Then you must write to the tribunal, ask the tribunal, send the award to the court, register with the court. Then after that is a court order. You can see the photo here. Okay, at the left-hand bottom, left-hand corner at the bottom there, you see there's a chop. Didaftarkan di dalam Mahkamah Section Magistrate Georgetown. Okay, with this one, it shows that it is already registered with the court. Then it has the effect of a court order. But to execute the tribunal award, you need go back to the court. You need to engage a lawyer filing to the court for summary action. But the court will not hear again the whole case. No, the issue of the merit of the case will not be heard again because the award already made by the tribunal. Okay, so they won't go lengthy again to hear the case, merit of the case. So they will only allow the summary actions to execute the award. So it depends on what types of action you want to take. So there are a few options here. Judgment debtor summon, JDS. If someone who is unable to pay, then you're not sure that whether he has any valuable item in his house can be auctioned, can be seized and can be auctioned, then you apply for judgment debtor summon. He must appeal in the court. Failing to appeal before the court, then the court will issue the warrant of arrest against the judgment debtor. Okay, he will issue the warrant of arrest. Then the bailiff will go to your house to arrest you, to handcuff you, take you back to the court for you to explain before the judge. Okay, how could you settle the debt owing to the GMB or MC? Okay, so if you want someone to be shameful over his arrears of service charge, then this may be one of the options. Okay. The second one is a writ of seizure. You can seize their item, then you can auction all the movable property in his house. Then for the third one is garnishing proceeding. This is quite effective if you are knowing that he has a bank account with certain bank. Okay, if you know he has a bank, let's say he has a bank account in Maybank, then you can apply to the court. You want to garnish the account. Then once the account is garnished, then the bank will deduct the amount and then pay back to the MC or GMB. This can be done by way of ex parte. This is an ex parte application. That means you can file the case without the knowledge of the defaulters. Then after you getting the award court order to garnish the account, you only need to serve to the defaulter. So they have no way to resist your claim. Okay, as long as there are money in his account. Then the fourth and fifth option is rarely used. But in fact, if someone owing you more than 50,000, you can apply to the court for bankruptcy proceeding. He can be made bankrupt due to the unsettled arrears owing to the GMB or MC. Or if he is owned by the body corporates, if the property is owned by the company, then you can file the winding up petition for that. Okay, another way is a credit reporting agency for blacklisting. I think this one is not so suitable for, except for the corporate owners. If your property is owned by the company sometimes they need to apply for the loan, bank loan, or they need to engage in certain other applications. Then these CTOS may be the helpful options. But it's a little bit more expensive for residential, for the GMB or MC, because you need to pay monthly subscription fees to make sure the blacklisting is still on there, okay, on the website. Okay, there are three ways to make a criminal prosecution against the defaulters. In fact, the law allows, even without going through the tribunal, okay, under section 34 bracket 3 for JMB or 78 bracket 3 for MC. If you are not settle your outstanding debt to owing to the JMB or MC, then you can be charged to the court. Okay, COB can upon the complaint made by the JMB or MC, then COB can open an IP and investigation paper against you, then take you to the court. Then this one you can on conviction, then you will be liable for fine not exceeding 5,000 or jail not exceeding 3 years or both. And in the case of continuing offense, to a further fine not exceeding 50 ringgit per day. What is means continuing offense? Means after the conviction, the court asks you, okay, after the conviction, the court asks you to settle whatever you owe to the management body within 30 days, let's say 30 days, but you still not pay after 30 days, then it's a continuing offense. So you still need to pay a further fine for that. So it means that even though you are not in prison, you are not sent to the prison by the court, you are only fined. Let's say you are owing 5,000, then you are fined 3,000 by the court. After you pay 3,000, the fine of 3,000 to the court, you still need to come back and settle your 5,000 owing to the JMB or MC. Okay, so you don't always expect that after paying the fine, you don't need to settle your arrears. Then it's very unfair to the management body. So for section 123, okay, 123 of the SMA, failure to comply with the tribunal award. This is for the cases who has filed to the tribunal and the award already obtained. The award usually will give you 30 days to settle whatever you owe to the management body. But if you do not pay for it, then on conviction, you will be taken to the court. The COB can charge you to the court. Then on conviction, fine up to 250,000 or jail up to 3 years or both. Continuing offense is 5,000 per day, okay? Because this is due to your failure to comply with the tribunal award. You still need to pay the arrears, no choice. And then, but tribunal cannot make any orders which may contain element of criminal sentencing of fines against you. Okay, you cannot go to the tribunal say, okay, I want to send the chairman to the court. No way. The tribunal cannot send anyone to the jails. Okay, so no way you can ask the tribunal to give you any sentencing of criminal in natures. Okay, right. Then this is a very interesting case. Prosecution by the Subang Jaya Municipal Council, the first of its kind in whole Malaysia. The defaulters, they do not pay. After the tribunal award is given, then they are prosecuted. Okay. So far, Subang Jaya is the only one local council take them to the court, prosecute them to the court. Okay, for failing to comply with the awards. So far, there are 3 cases being sentenced by the magistrate court. Okay, the first case is 1,500 or in default 5 days imprisonment. If you do not pay 1,500, then you have to serve the jail term for 5 days. Okay, the second case is 3,500. The third case, the lately one in July after MCO, is 500. It's getting higher and higher because it's allowed up to 250,000. Okay, so we hope that no one will take it lightly. If you are the defaulters, try to talk to the management body, try to talk to your property manager to seek to arrange to enter an installment plan. Okay, if you are really have a financial difficulty or having the financial stress, talk to them. Enter an installment plan. As long as the installment plan is still in place, no one will take you to the tribunal or no one will take you to the court, definitely. All right. So can the tribunal award be challenged? Definitely, it can be challenged. But you cannot, even though you can only file judicial review to the High Court. Judicial review means if you think the award has serious irregularity, Okay, what is serious irregularity? You refer to A, B, C. Failure by the tribunal to comply with section 113, equal treatment of parties. If the tribunal president is biased, only hear one side, did not hear the argument from the other side, then this is a failure to comply with section 113. It is considered serious irregularity. Or failure to deal with all the issue being put up in the tribunal, or uncertainty or ambiguity as to the effect of the award. Only on these three grounds, you can file your judicial review to the High Court. But even with the judicial review being successful in the High Court, it doesn't mean that you can reverse the whole thing immediately. Or the High Court cannot overrule. The High Court cannot overrule the decision made by the tribunal. Okay, he can only remit the award either in whole or partly back to the tribunal for reconsideration, or set aside award aside in whole or in part. That means the case will be remit back to the tribunal again for retrial or for hearing again. So judicial review it's not like the court of appeal. Okay, you cannot, the court of appeal, if you are convicted in High Court, then you file to the court of appeal, then you can reverse the whole thing, the whole sentencing, or you are convicted by the court of appeal, then you can go to the federal court. That's not the way. Judicial review is to rectify the weaknesses of the tribunal or the weaknesses of the award given by the tribunal. So it's not worth to try. It's a very expensive option because you need to engage a lawyer, go to the High Court to file for judicial review. You need to do a lot of paperwork. And so far, I do not hear any of successful judicial review case filed in the High Court to reverse any order made by the tribunal. Okay. These are the last two parts. I think a lot of people are quite concerned on that. Interflow leakage. Okay, these are part of the tips I try to give by today. Always remember, okay, because Strata Management Act is also Act 757. These are the keyword you would need to know. 757. Okay, the seven refer to the first one, the first 7 days. When you are the management, you receive a complaint from the affected owners. Okay, he complained against the interflow leakage happened to his unit. Then within 7 days, you must make the inspection to the unit. Definitely the affected owners, they will allow you to go in, but the responsible owner will not allow you to go in his unit. Okay, he will deny his responsibility. But whatever it is, the inspection must be done within 7 days. Okay, after inspection is done, then the management has to produce Form 28 within 5 days. Okay, to name the responsible party. But if you are not able to go to the upper unit, then how could you know whether the upper unit should be responsible over the leakage? So the law allows presumption to be made. Okay, based on the principle of presumptions, in the absence of a proof to the contrary, if there is any dampness, moistures, or water penetration on the ceiling, you can presume it was caused by the upper unit owners. Okay, you name the party. Okay, unless the upper unit owner is able to prove that is not due to his problem. Okay, then after Form 28 issue, you must issue to the affected party. You must issue to the responsible party. Definitely the management must keep his own copy as well. Then you serve to the responsible owner one copy of the Form 28. Ask him to carry out the repair within 7 days from the date Form 28 is received. Then, failing which, the management committee has to carry out the repair works and then to claim the cost from the responsible owner. After 7 days, if the responsible party doesn't want to repair, then you go back to the management committee. Now is your duty and responsibility to repair for me. then management body cannot say, I don't have money for that. That is not the excuse can be accepted in the tribunal. Okay, in the event of any dispute over the cause of the interfloor leakage and who should be responsible over it, then both parties can go to the tribunal, ask the tribunal to appoint an expert to carry out the inspection work for you. Okay, usually the tribunal will assign the JKR to send his technician to the site to carry out the inspection work. So that one you don't need to incur additional cost for it. Okay, so any dampness, moisture, or water penetration on the ceiling, then you can presume the upper owner should be responsible. Even on the party wall, okay, let's say your party wall, your side wall has moisture or dampness, then you can presume the adjoining unit owner must be responsible over it. Okay, it is allowed. Okay, they cannot claim for defamation or whatever is. Okay, presumption is allowed under the law. Then causes of interfloor leakage. Okay, these are three types of interfloor leakage. The first one is caused by a defective workmanship within the defect liability period. Usually, after you take, you buy a new house, you take the new key, then from the date of vacant possession within 24 months, you can claim against the debtor. Okay, for this case, you don't need to go to the tribunal, Strata Management Tribunal. In fact, you can go to the Tribunal of Home Buyer's Claim because it's about the debtor's duty. But if the interfloor leakage was caused by other parcel owner, then you can make a claim against the responsible owner and also the JMB and MC to be then this case to be filed through the Strata Management Tribunal. Why you need to make the JMB or MC to be one of the party? Because the law says clearly after 7 days, when the responsible owner fail to ratify it, then JMB or MC must ratify it. If you do not name the JMB or MC as part of the claim, one party to the claim, the tribunal cannot make any award against the JMB or MC. So then it's advisable that you name two parties in your claim. Okay, the first respondent is the upper unit owners. The second respondent is the JMB or MC. Name the JMB or MC. Okay. Then for the third one, if any leakage due to the caused by the common property or the attributable to common property or limited common property, then is the duty of the JMB or MC or the debtor. If before the JMB is formed, then it is under the debtor. Or if any leakage, if you are the top floor owners, any leakage from the rooftop under the law is common property. Okay, the management has no right to say it's not part of his duty. When it's common property, then JMB MC has to take the responsibility. Okay. All right. So these are some tips given for you. If you want to make a claim, then you file against the MC or JMB. Then it will be binding on the JMB and MC. And then you try to source for your own quotation. In case the claimant prefer to be compensated monetarily. Okay. So no claimant. In fact, the upper unit owner, the responsible party, he want to pay monetarily. Okay, he doesn't want to engage his technician to do it. He say, okay, fine. You want to make a claim, you have such a problem, you engage your own contractor. As long as I can agree to your quotation, this can be done. Then the JMB or MC cannot rely on financial stretch as is different for not carrying out the repair work. Then one more duty for the JMB or MC. In fact, even though the upper unit owner doesn't want to give you the access, the JMB or MC must issue notice of 7 days for access into the premises, or failing which it is a criminal offense. Forcible entry can be affected. Okay, if in the case of emergency, if the unit is not occupied, no one is inside there, but there's a likelihood of a flood or danger to the life or property, then you can make a forcible entry, go into the unit. Okay. In the case of emergency, you don't need notice of 7 days. Okay. But in cases of non-emergency, you give 7 days notice. If there is a need to break in, then you have to break in. Okay, one more thing, one more aspect. Warrant or attachment. In fact, this is nothing. Is not directly relating to the tribunal. Even though without going to through the tribunal, you can still get a warrant of attachment. Okay, so you apply to the COB. Okay, to any defaulter doesn't want to pay, then you apply to the COB for a warrant to be signed by the COB. Then you can go into the unit to attach all the movable property can be found in the state. Listen carefully, can be found in the state, not only in that project. Okay, if you know he is living in somewhere else, he has other properties, he has other valuable thing in other place. As long in the same state, this warrant can be enforced. Okay, then you go to there, you try to attach whatever movable property inside the unit. You move out, you seize the item you kept in somewhere else. After 14 days, if he still refuses to pay for that, then you can go for auctions. Okay, you can auction all the movable property, then you get back the money you want to recover from. And then you cannot use tribunal award to apply for a warrant of attachment. You don't need for that. If you want to apply warrant of attachment, after issuing Form 11 or Form 20, you go directly to the COB to apply for it. You don't need any award for that. In fact, you cannot use award to apply for warrant of attachment. So this is lately one action we taken in Penang against a defaulter of 12,300 something. This defaulter owing since 2015. Okay, living in Eden Fairway condominium. Okay, then this is the inventory. Okay, inventory of the item we seized from her unit. All right. So after 14 days, we can go for auctions. So what else you can recover from the owners, from the defaulters? You try to recover whatever he or she owing to the GMB or MC. You can also claim other things like the filing fee. You apply for warrant of attachment, then you have to file Form 21. Then it will be 20 ringgit for each unit. The expenses for the maintenance of livestock, the cost of appointing an auctioneer, the cost of advertisement of the auction, the cost of hiring watchmen, okay, keep possession of the movable property attached, transportation costs, insurance, storage, security, you can claim from her, okay. And then a sum of 300 or equivalent to 3% of the amount due, whichever is higher, you can claim as administrative charges. Then if you go for such an option, you can claim more than what he or she owing to the GMB or MC, based on whatever expenses incurred by the GMB or MC. All right, now I think should be come to the Q&A. I refer back to the Casey.
Yeah, thanks, Mr. Ng, for explaining all this. I think it's very clear, like very clear, all the audience will know what to do when they face kind of problem. So I think the first questions will be like, when should we go for COB first, or we go directly for the tribunal?
Sorry.
Yeah, my question is that when we have a situation where we want to claim, so should we go for always go for COB first before we go for tribunal, or?
Okay. If you want to claim any arrears from the defaulters,
yeah,
if you do not plan to apply for the warrant of attachment, you can directly go to the tribunal. Okay. Now it's still a situation where in a lot of places, the COB quite reluctant to issue any warrant or attachment.
Mm-hmm.
So far, in the Municipal Council of Kajang is the first one in whole Malaysia. They have taken the action in the first warrant of attachment in 2017. But even though with that precedent, when we push for the Penang Island City Council for that, initially they are quite reluctant. They are quite reluctant. Maybe something is very new to them. They never did this before. They are quite reluctant for that. But after pushing for some years, finally we get the. This is the fifth warrant given to us. The fifth warrant issued by the MBPP, and then the first execution of warrant attachment in Penang State. Even after he issuing the warrant attachment to us, he still tried to ask us whether he still tried to test us whether we are really serious want to execute the warrant attachment. Okay. He even on the day of execution, he tried to advise us, oh, if the unit is not occupied by anyone, you don't try to break in. They try to stop us from break in. But in fact, the law allows us to break in. Okay? Even the unit is empty, no one inside the unit, no one is occupied, the owner is not there, you can break in. Okay? Even though the unit is occupied by a tenant, you can seize the item of the tenant.
Whoa.
So every tenant, you still have the duty and responsibility to check whether your owner has paid for the maintenance charges.
Fee, yeah.
Or if not, the COB, the management body can use warrant, come to your unit to seize your item. And definitely the tenant has an option. In facing the warrant of attachment, the tenant can help the owner to pay and then deduct from the rental payable money to the owner.
Okay, I see. So that might be a viable option too.
Yeah, but if you don't want to go through the tribunal option, then you can directly go to the COB for warrant of attachment. But it still depends. Lately, when I approached DBKL for that, I think they are still given a lot of non-excuses in refusing to issue the warrant of attachment. But anyway, we will try to push for that. Okay.
So the moral of the story is that it's not easy to get the warrant of attachment, right? It depends on the COB, and of course you still have the tribunal to go to.
Yeah, you can go to the tribunal anyway, and then the most important, I think you need to get back the money. That's important. As long as you can get back the money, then you try the tribunal option. But if the tribunal option is still not helpful, you cannot get back the money, even you try to garnish the account, the bank account, the bank officer told you, oh, there's not much money in the account left in the account. You are not able to garnish the amount. I have one case, even only less than 10 ringgit in the account.
Oh.
The bank finally issued us a check of less than 10 ringgit. Okay.
So go through all the trouble so he's gonna get the money, right?
Then another one, when I served to the bank, the bank say, wow, this owner, although he has a bank account, but not much money, only less than 150 in the account, and then he has another court petition, try to recover 50,000 from him. The court order served to the bank, so no way to get the money at all. Yeah.
Okay. So let's get to some question here. Is it toilet waste pipes that's exposed to the lower unit toilet? So who shall be responsible for the waste pipes leaks or spoil?
Okay, this one you must able to differentiate which one is the common pipe, which one is the not common pipe. Okay, for common pipe, it is the responsibility of the GMB or MC to repair it. Like it or not, they cannot reject your request. If common pipe, if one pipe from the top unit until the lowest unit, one common trunk of the pipe, then this is we call it common pipe. So that one is the responsibility of the GMB or MC. But any subsequent pipe connected to the main pipe, then that is the responsibility of the individual parcel owners.
I see. Okay, depends on which pipe is it. So okay, if the sales and agreement, the maintenance charge says just 1 ringgit 20 cent per parcel unit, but when delivering the VP, the developer changed the maintenance charge to 1 ringgit 70 cent. And then can the purchaser file a case to tribunal in this?
Okay, definitely, because I think when Dapper signed the SMP with you as a purchaser, definitely he has made his own budget, he has made his own calculation. Okay, and whatever maintenance charge imposed on you must be based on the share unit as well. So the budgeting must be done based on the expenses for the next 12 months. For the next 12 months, then deducting by the share unit, then you will come up to a sum how much you need to bear for every unit. Even though the GMB, even though before the formation of the GMB, the debtor is still fully in charge, I think you are still able to challenge that because the debtor only in charge of 1 year, within 1 year after the VP. So I think it's not, I think he has not much excuses why he need to increase immediately on the service charge. Okay, even though maybe the debtor has to incur a lot of unnecessary expenses, or he has to incur more expenses than what he budgeted. I think that is the issue he has to try to solve with the GMB later. After the GMB taking over, then debtor may try to recover back from the GMB or MC for whatever additional expenses incurred by him. But I think not at these junctures. Within 1 year after the VP, the debtor should increase the maintenance charges unnecessarily. Yeah.
Okay.
Yeah,
so of course you can make a claim, right? Okay. Nana want to know, is it I have received an award from the tribunal. So the defendant has to compensate my loss about 1,200 ringgit. So she's asking your advice. Is it appropriate to file the saman penghutang penghakiman, debtor's summon, or the garnishee proceeding against the defendant? What do you think?
Okay. Definitely, you can file whatever action you want. Who is the respondent? Debtor.
Yeah, who is the respondent? He's not stated here. Not stated here. I don't know whether developer or...
The first thing, if you want to file a garnishee proceeding, you must know in which bank he has the account. Okay. So sometimes we have this problem. We don't know in which bank we have the account. I have few attempt before. I tried to put all the local bank in one application. There are only 8 local banks. So I put all the name of 8 local banks in one application for the garnishee proceeding. But it depends on whether the magistrate allow you to do so or not. Some magistrate won't allow. Okay, some magistrate they turn down. They won't allow for that. If the magistrate allow, then you can tembak buta lah. You can go to every bank, ask your lawyer, serve to every bank. Then the bank will come back to you whether he has account or not. Okay, but some magistrate will not allow for that. JDS is a way you can get the opponent party get the ability to issue the warrant of arrest to take him back to the court to explain to the court how much he can pay you. If he has the financial difficulty, let's say the court say, okay, since you have financial difficulty, you are not earning a lot every month, maybe I make an order, you must pay 300 per month until you fully settle the amount due to the claimants. So there's a way. JDS, you can try JDS. But if his unit has a lot of valuable thing to be seized and auctioned, you may try WSS as well.
Okay. So continuing with the questions, right? Now I want to know. So far, all the documents served to her is returned. So it's like serving via courier service as a valid enforcement as well.
In fact, you only need registered post. Okay. You don't need to engage courier service. Okay. As long as you're using the registered post, or even you use the AR registered post, as long as it's sent out is considered served. I don't need to prove that whether he received it or not.
Okay, good. Let's do another 5 minutes Q&A, right? Because we
Yeah.
know running over time. So on committing overstating their stay, what if the property does not have enough owners who want to serve in the MC or JMB? Is the law allow any leeway to overcome this issue?
Yeah, this is one of the problems we are always facing. Sometimes not so many people are interested to turn up in the AGM or EGM. Don't want to. A lot of people doesn't want to. They don't want to serve as a committee members, and we have left with no choice, and then we have to elect back the same person to continue. As long as no person make the complaint to the COB, then I think that is not much issue for that. But if any owner, if just one owner make a complaint to the COB, then his qualification will be affected. He will be asked to vacate his position. So it depends. If you can convince those attended the meeting, okay, this is the situation we have, and no, since not much people interested to be the committee, then we have no choice to elect back the same person, and then we hope that you can accept it. Make sure no one complain to the COB. Advise them not to make any complaint to the COB. Yeah.
Okay. I want to know, I think this is more about property management. Said, can I request for invoices to be emailed to me? Because the JMB refused to do so and continue to insert invoices in the mailbox of my vacant unit. So as a result, sometimes no payment was made late, as I would not know when the certain invoices are issued by JMB.
In fact, you have every right to request for it to be sent through the email because they will not incur additional costs. If by posting, maybe some of the management body, they will ask you to pay some postage for that. Okay. But I think by email, you won't incur any additional cost to the management body.
I think the JMB should gladly do that too, right? It's saving money.
Definitely. But even without receiving all these things, if dress in receiving the invoices, corporate owner they need the invoices before the expenses can be approved by the company. Individual owners, even without receiving all this, I think you know how much you need to pay money. But if the management body is quite helpful, then I think you don't have the problem. But if they are not helpful, accessible to your own account, I think some of the high-rise project they have used their own apps, or they have used their own online portal for that purpose. You can be given the ID and think that should not be a problem. Okay, it's quite common nowadays.
Okay, good. Just answer one more question here. I have Evelyn say I have a tree grow outside of my apartment unit wall and would like the management to remove it. So if the management did not remove it, can I file a claim through the tribunal too?
Anything on the common property is under the duty and responsibility of the management body. Yeah, you can always file against them.
Okay, thank you very much. So before I let you guys go, right, to enter the lucky draw for the books giveaway, I'm going to give away 5 copies to a lucky winner. You can just share this video, share it on Facebook, and then hashtag Strata Management. And also, if you want to get the book, you can buy it through MPH online, or also you can contact Wei to purchase a copy too. So do you want to put up the slides that have your contact information so that they can reach you too?
Yeah, no problem. I can, no problem. Later, I think you will send to as well. Then you can go to my Facebook, type in my name, then you can find the information on that. Yeah.
Yeah, great. Anyway, you can always find his book in MPH online. Okay, no problem with that. And also,
MPH online is available.
Yep, nice. And then in the thanks guys for tuning in, and thanks Mr. Ng for sharing all this information. And for the next webinar, next week, I'm going to host Casey Chong. He's also a book author and he's an investor, very good stock investor in Malaysia. And he has the book called The Complete Value Investing Guide that works. So I'm going to have him, I'm going to host him on the next session. So if you want to learn how to do profitable stock investment using value investing method, which is very safe to do, please tune in. And also, if you want to get the notification of all my future webinar, which are free, can get on my email list, or you can follow my Facebook page. So thank you, everybody. Thank you, Mr. Ng, for doing this for my audience. Really appreciate it.
No problem. Thank you. Thank you,
Thank you.
everyone.
Bye-bye.
Okay, see you.
See you.